Can everybody hear me okay? Yeah. I'd just like briefly, before I start, to cover a couple practice points which were not covered during the course of the presentations today. They just come to mind. So the first one is with respect to PCT applications. When you file a request, there is a Section 6. Section 6 is the list of declarations or statements that people can sign. One of them is the PCT form declaration. So a good reason to have that signed by the inventors when you file the PCT application is that the signing of that declaration, filing of the PCT request with that section, that specific declaration in the request, signed by the inventors, complies with the 371 National Stage Entry requirement for signed inventors declarations. You can read through the rules and comments, but that is the law under, I think it's Rule 1.496 or 1.497. It's been the law. Few people recognize it, but I confirmed with the PCT legal that that is the way the PCT, the receiving office, the designated office here treats, the office that takes the national stage filings treats the signed declarations in the PCT request. And there's a reason to do that, which is when you enter the national stage, the U.S. national stage from a PCT application, the requirement that is normally outstanding is the inventor's declarations. And in many cases, if you look at the files for other practitioners, you'll see that the inventor's declarations come in a few months later when your foreign colleagues get around to signing them and having them submitted to you. Well, that's a problem in the sense that the patent term adjustment accrues in a 371 application from the date you comply with the national stage requirements. So you're cutting off patent term by filing inventor's declarations in 371 applications late. That's one reason that prompted my question about the U.S. cases. U.S. applications, as opposed to PCT applications, don't have that requirement. The inventor's declarations apparently can come in late. There's no specific rule that specifies and no statutory requirement that specifies that patent term adjustment depends upon when you file the inventor declaration in a U.S. application as opposed to a PCT U.S. national stage application. So that's point one. Point two is that it's very clear from the comments on the rules on inventors' declarations that if you file an ADS that has all the requirements, but the ADS is unsigned, the PTO will essentially ignore it. It's legally ineffective. And of course, the application data sheet now is essential because the application data sheet is where you must make all your priority claims, amongst other things. So if you don't have a signed application data sheet in an application when you file it, then you have committed negligence. The other point with respect to the application data sheet is that is where you identify who is the applicant, if you want the applicant to be other than the inventor. So with respect to the application data sheet, when you file a new application and you want other than the inventor, aka the employer or the corporate entity, to be the applicant, you need to make sure that application data sheet is signed. I bring it up because I have seen unsigned application data sheets. Okay, so with that, where are we? Let's go back to slide one, please. Okay, so I guess I like to start off with a quote from Rumsfeld, the former Secretary of Defense. You recall this famous quote where he said, "We go to war with the army we have, not the army we want." Well, we have the AIA. It perhaps is not what we want, but it's what we have, and we have to use it. So I will talk about some perspectives that relate specifically to corporate practice. That was my charge for this talk. So I will look at corporate practice. But in thinking about the talk you're going to hear shortly, another comment comes to mind from a colleague in an interference years back, four-way interference, very complicated. And we had a Dr. Battery, it was a battery case. And we had a declaration that was hundreds of pages long. His comment to me, and this was opposing counsel, was that in reading Dr. Battery's declaration, he was overwhelmed by boredom with distinct moments of sheer terror. So you may be bored by part of this presentation, but there are significant points where you won't be terrified, unless perhaps you realize that you're in the situation I've identified. Okay, so what I will do now is give you the flash forward. I'm going to look at or talk about third-party submissions in a context broader than the Patent Office and relate that to the monitoring activities of companies. That'll be point one. That's sort of a distinct segment. After that, I'd like to parse through the first inventor to file law. And I'm always nervous about this because the first inventor to file law is a detail-oriented law. Every word matters, and there's exceptions within exceptions. I will go over it piece by piece to try to identify to you, to get it in your head, how the separate sections of 102 relate to one another. Well, we'll find from that there's a gap. There's a missing piece in the new 102, which has been referred to earlier today in passing. And that segues into the next section, which is how do corporations retain rights? The missing piece has to do with rights. And so that requires, in order to proceed in understanding or review of ownership and assignment law with respect to inventions. So that'll be section 3, ownership and assignment, and there'll be some of those sheer terror moments in that section. By the way, the poll of the audience, who here has filed a PCT application for a client? Who here has filed a PCT application for a client and not confirmed that all of the inventors in a priority application had assigned the rights to the company? Anybody? Okay, you may have a moment of sheer terror. All right. After that, by the way, this thing keeps slipping, but so I'll be going back with slides if they slip inadvertently. After looking at the law of ownership and assignment, we'll try to apply that to corporate rights to see what corporations can do in order to avoid a loss of rights and protect the rights that they should own. There's a large section, section 5 after that, dealing with prior invention, the concept of derivation, how one would go about showing that a disclosure originated from the inventor, and the like. That's more than we can cover today. The formalities for the declarations are, they're not formalities, but they're not terribly interesting in themselves. The derivation law is, the idea of derivation petitions is, so instead of going through that in any detail, I'll skip to the summary slide at the end to give some practice points. Okay, so company perspectives. Now we've heard a lot about the, we've heard a little bit about the right to pre-issuance submissions. Basically, under the AIA, U.S. statutory law now provides an actual right, a strong right for third parties to comment on pending patent applications. And this is, of course, new. The old regulatory authorization was that you could file a reference within 2 months from publication, and that was it. You couldn't say anything. Under the law and under the promulgated regulations, you have a substantially longer time period in most cases to file a submission, and instead of being just authorized, you're required to identify the relevance of the submission. Now, this is the coming wave. It's not just the United States. The same abilities, the same infrastructure now exists in major patenting jurisdictions around the world. So while this is true in the US, it's also true in WIPO, and it's also true in the EPO. And by I say also true, I'm referring not just to the right, but to the ease with which these submissions can be made. Well, that brings up something which many of you are peripherally aware of, which is monitoring. If you're at a small or mid-sized law firm or a large law firm, perhaps you don't think of monitoring as an activity, but most companies and inventors that are patent savvy monitor the competition, and they do so from time to time, various means. That activity is now substantially more valuable. It's substantially more valuable Let's go back for a second. Get back on track. The slides keep slipping around. Okay, it's substantially more valuable because you have substantive rights, which are easy to effect, to block or questionable claims of your competitors around the world. And of course, there's various ways to monitor. You can go directly to the governmental databases. You can hire a searcher, a contractor, a service. There's an organization I should ping called the Patent Information Users Group. You can Google them, look them up on the web. They're extremely knowledgeable about what can be searched, how to search, where to do it. In fact, they have a conference coming up next week in New Jersey. So there's various ways to do that, but the concept is we're talking about monitoring published applications around the world. And of course, the value is that if you monitor and you submit, you may avoid the cost of litigation, you may avoid having to design around, you avoid uncertainty, and the traditional benefit of monitoring is you get to know what the competitors are doing and think up new inventions based upon their inventions. Also, as a peripheral issue, there's still a law of interferences for pre-AIA cases. Post-AIA, there'll be a derivation law, and timing for submitting claims matters under both of those laws. So you want to monitor it so that you can basically copy claims when applicable. Okay, so now on to the actual provisions. We have a new section of 122. That's a publication provision of the statute. It's 122E, and that's what provides for this right for third-party submissions. The submission must be a printed publication or more than one printed publication, and you must include a concise description of relevance of each document. The timing is, well, the regulatory timing is a bit tighter than the statutory timing. The statutory requirement was that the statute gives you 6 months after publication, well, the later of 6 months after publication and final rejection. The regulation limits that to the later 6 months after publication and first rejection. The PTO's reasoning is once you start substantive prosecution, once the examiner starts substantive prosecution, you don't want to be bothering him and mucking up the relationship between the examiner and the applicant during the active phase of prosecution. That was the reasoning in reducing the time period to the extent they could by regulation. And in any case, such a submission must be made no later than the date a notice of allowance is issued. And the golden points, one of them at the bottom here is that you can do this via EFS. It's easy. You just upload electronic documents, no need for paper, no service, no nothing. That's great. Let's see. Okay, this provision is not available to the patent applicant for obvious reasons. You don't want to be having an applicant doing an end run around the IGS submission requirements and their fees requirements. And another golden point for the U.S., at least for small submissions, 3 references or less, you have no fee for the first submission by any third-party submitter in any particular application. If it's more than 3 references or it's after the first submission by the same third party, then there's a small fee associated with it. It's a detail, but the point is, without having the cost of doing the accounting, this procedure is even easier. There's no requirement to bill a client, to enter the fees, give your credit card, etc. So it's fast, quick, and easy. And the PTO's requirement, which I was asking Janet about earlier, is this in-camera review. It's clear from the rules that the PTO has updated its infrastructure such that when these submissions are filed, they go into some cubbyhole where they're not available to the public until after the PTO checks to make sure you've complied with the regulatory requirements. So the PTO will screen the submissions and release them to the IFW once they have been checked to comply with the requirements. Once they're in the IFW, the patent owner has no duty to respond. They're there, right? The examiner will look at them. And I understand they will show up on the issued patent as a subset, a third set of references. So you have instead of 2, 3 sets on the face of the issued patent. Well, you'll have a list of references, and they'll show up there. I'm unclear as to the detail of how the patent office will print those on the issued patent. Janet, do you want to comment on that? Will it be a separate section listed for the references in the
Yes.
third-party submission?
On the face of the patent, there'll be a section for documents that the applicant has submitted on an IDS form, and another section for a listing of the documents that a third party has submitted through a pre-issuance submission. So when you look at the face of the, member of the public looks at the face of the patent, they can clearly distinguish what documents came in through what mechanism.
Okay, so we have this right in the U.S. We have a similar right now under WIPO. WIPO has a electronic infrastructure and authorization to accept third-party submissions in patent and PCT applications. So, same thing, it's electronic. The difference here is instead of using EFS, you have to use ePCT Public Services. This is a service available to anyone in the world that has a computer. You just sign up for the service, get an account, and then you can, when you look up a PCT publication, you click the third-party submission button and fill out the form requirements and upload your submission. So just like the U.S., it's easy. You can do it. And the EPO, one more point about PCT, you have 28 months from the priority date to make such a submission. After 28 months, the WIPO is pretty much done with the application. They've already sent it off for national stage, and the national stage officers are dealing with it. When you make such a submission in the WIPO site, the references will be available to the applicant, and so will the concise statement. The submission will be available to the applicant. It will also be made available to the ISAs, IPEAs, and DOs generally. So the references you submit will be effective in that PCT application globally. As I mentioned, EPO has a similar facility now. Theirs is a bit simpler. You simply upload them to an HTTP site. There's a form on the web. You fill it out. You upload your observations and your citations. And as long as they are directed to the substantive requirements for patentability, you've made a compliant submission. The EPO's timing is a bit different. They're very lenient. After the EP application publishes, at any time when there's a proceeding pending in that application or a subsequent patent, you can make such a submission. Okay, so that's it for third-party submissions. It's a right globally available now. This makes monitoring extremely valuable, much more so than 5 or 10 years ago when you had to think about contacting counsel overseas to make a submission to challenge someone's patent application. You can do it yourself. You do it from your desktop. No outside counsel required. Okay, now I'm going to get into the more difficult task of parsing 102. So 102 is the new section of the statute under AIA that provides for the first inventor to file or disclose novelty. It has some subsections, and all sections have the effective date of March 16, 2013. And then it has this strange applicability provision, which basically says once you switch, you can never go back. So once you go to first to file, you can't go back to first to invent. The way I phrase it here is it applies to any patent application that claims priority to an application, or is an application that ever contained an invention claim with an effective filing date after the switchover date. If that's the case, then this 102 applies. The new 102, the first to file 102. And the first to file 102 has basically two prior art sections, 102A, which has some subsections, and 102D. Those are the prior art sections. They define what is prior art, except for the exceptions. And the exceptions, and they're called exceptions in the statute, are defined by 102B and C. Oops. So under 102A1, there's this phrase in that section of the statute, quote, otherwise available to the public, which you've heard before. And before that phrase occurs the terms that define what's considered a public disclosure: patented printed publication in public use on sale or otherwise available to the public. And that, if that occurs before the inventor files, then you have prior art to that filed invention. And the other section, or coupled sections, are 102A2 and D, and those relate to patent documents, patent publications. So another is U.S. patent publication as of its priority date. This is the big change, priority date, whether it's U.S. or foreign. If that priority date is before the inventor's filing date, that's prior art under 102A2 and D. The statute refers to deemed a publication under 122, and 35 U.S.C. 374 has that deemed a publication under 122 language in it, which means that PCT publications qualify. So someone publishes a PCT, someone files a PCT application that claims priority to Zimbabwe, and then that PCT application publishes. You have some very strange prior art, but under U.S. law, it's going to be prior art under AIA, which is what we have to live with. Then there's 102B and C, the exceptions provisions. So 102B1 is a grace period, quote, grace period. It's an exception from prior art. The statute calls it an exception. So this has to do with 102A1. The B tracks the A, so B1 tracks A1, 102A1. So for a 102A1 disclosure, within 1 year of the inventor's filing date, there are some exceptions. One is 102B1A, and that is when the disclosure is an inventor-originated disclosure. So say you are an academic and you have a paper and it's published before your slow patent department gets around to filing the application. Well, theoretically, that will not be prior art against you because it's your disclosure. It originated from you. That's the concept behind 102B1A. Then there's 102B1B, which is an inventor-originated public disclosure. Okay, so you have an inventor-originated public disclosure. So say under 102B1A, the disclosure was private and somehow it got out, became public after you disclosed it to a colleague. Under 102B1B, you must have an inventor-originated public disclosure. So say you take your patent application, before you actually file it, and you publish it in the newspaper. Crazy thing to do, but just to give you an example, you have a published disclosure in a newspaper, right? And then a third party comes around, say in China, and they have a disclosure. And then you file. So you file after the third party's disclosure. Well, theoretically, so theoretically, that third party's disclosure can be disqualified because you disclosed first, even though you filed after, theoretically. The idea was it would make sense if that was the way the law specifically was interpreted. That's the basic core provision, though. One and two B2. So there's a B2 provision which tracks the 102A2 provision. 102B2, which deals with earlier filed patents and the exceptions from prior art for earlier filed patents that have an earlier priority date than your application. So under 102A2, a U.S. patent publication will not be prior art as of its priority date if the disclosure of that patent application was an inventor-originated disclosure. It came from the inventor, someone else filed, including their disclosure, including the inventor's disclosure. Under 102B2B, the inventor had an inventor-originated public disclosure before the third party's filing date, before the third party's priority date. If the patent publication's disclosure is the same as the inventor's prior public disclosure, then it's accepted from prior art, theoretically. And I say theoretically because you all understand there's issues. Now, 102B also has a B2C provision, which corresponds again to 102A2. And this is the co-ownership provision. So if you work in a company and everything's co-owned, then the filing of one application as of its filing date is not prior art against a subsequent filing, as long as the subsequent filing is before the first application publishes. It's the filing date that's accepted, right? Prior to accepted from the filing date of this provision. Well, that's it for the 102B2 exceptions. There's also the 102C exception. And the 102C exception is the exceptions from prior art when you have a joint research agreement. And if the JRA was, quote, in effect on or before the effective filing date of the claimed invention, unquote, well, that's a little different from the JRAs before under existing first to invent law. Under first to invent law, it's the date the invention that's made that counts. Under the AIA, for inventions made subject to a joint research agreement between parties, it's the date that the claimed invention was first filed. So you can imagine situations, which I'll look at later, where parties disclose information, they decide to go ahead with a joint research agreement, but they hold off on all filings until the agreement's in place, and then they file. Well, guess what? Those delayed filings affected a removal of prior art. Okay, so we've gone through the statute and the exceptions. What in the world does all that mean? Right? We know what the words are. We know what Congress wrote. We know there's contentions. And so we have to look at the contentions and see what the Patent Office says and look at a crystal ball. So that's the next step. So 102A1 says, quote, the claimed invention was patent described in a printed publication or in public use, on sale, or otherwise available to the public. Words in bold and italics have particular interest in that section. So there are comments. The PTO has a comment on or otherwise available to the public. And their comment is that, well, Congress clearly meant that it does not cover non-public uses or non-public offers because they said otherwise available to the public. And those things aren't available. So we're reading the statute to mean that non-public offers and non-public uses are not going to be patent-defeating events. That's nice. Some people think they're right. Some people think they're wrong, as you've heard earlier today. But the PTO's position is clear. We, of course, have to wait to see how a court or the Supreme Court decides that or those issues, because this does not give us legal certainty. Despite, or in addition to the fact that PTO doesn't have substantive rulemaking decision, the authority grading flows downward from the Supreme Court, not up from the Patent Office. Okay, looking at the B provisions, 102B1A says a disclosure is not prior art if the disclosure was made by the inventor or joint inventor or by another who obtained the subject matter disclosed, emphasis provided, directly or indirectly from the inventor or a joint inventor within the 1 year, quote, grace period. Well, the PTO's comment, and this is extremely important. Wake up at this point if you're asleep in the audience, is that even if the only difference is between the subject matter, remember that section of the statute refers to the subject matter, in the prior art disclosure that is relied upon to reject a claim, and the subject matter publicly disclosed by the inventor before the disclosure by the other party, are mere insubstantial changes or only trivial or obvious variations, then there's no exception. That disclosure after the inventor's disclosure, if it's just a little bit different, well, boom, guess what? That exception doesn't apply. The PTO, I'm going to back up one slide. The PTO has read subject matter, the subject matter, to mean identity of subject matter. And these are proposed, this language, their comments come in the proposed guidelines for examination. Remember, AIA is not yet in effect as to the 102 provision that comes starting next year. The PTO is almost ready. They've got the proposed guidelines out and have requested comments. So this is, I believe, where we stand. Okay, so the problem with that, of course, is you have no grace period if that's the case. If you have a disclosure and someone else, theoretically changes the word the to changing the meaning of multiple to singular or plural, that's an insubstantially different change. That disclosure by the third party after yours is now a patent-defeating event. If you file after that, that patent-defeating event exists as prior art under 102. So it's a problem. There were some comments earlier about getting a picture claim if you have a disclosure and someone then has a subsequent disclosure, and this turns out to be the status of the law after court review. You could only get a picture claim if the third party's disclosure didn't disclose what your picture was claiming. If you publish your patent application, which contains all of your disclosure, as an example, before you file, then the third party takes that and changes the word the to or makes a minor substantive change, republishes it. Under this provision and this interpretation, that third party's republication would be a patent-defeating event if you later file your patent application. That's the implication of this interpretation. Well, some people think that's not really what Congress meant. At least the AIPLA does not think so, and that's what they stated in their comments, that that would undermine the intent of Congress. And the AIPLA gives a suggestion about how you can slice and chop the subject matter term to mean material relied upon by the examiner for rejection, for example, such to the extent that it's different from the applicant's public disclosure that they're relying upon for an exception. I'm not sure that will fly. Now we're getting into policy issues and trying to look in the crystal ball where the courts will go with this issue or where the Patent Office will go. Remember, of course, the Patent Office is the gatekeeper. They have to reject claims to have issues percolate up promptly to the courts for review. This is an issue that they have taken a position on for that purpose because the courts need to review this issue and give us clarity on this section of the statute. But in the sense of looking at policy and perhaps best practices, this issue is almost exactly analogous to the issues the CCPA faced after the 52 Act with respect to antedating a reference. So 52 Act, we have the First to Invent Act, right, First to Invent system. And you have an invention, you have proof of the invention, and then there's an intervening reference, and then you file. Well, to what extent can you antedate? Now, there's three balls in the air here. There's the invention you made, which corresponds in the current parlance under AAA to your disclosure, or you could disclose publicly. There's the third-party reference, which corresponds to the third-party disclosure before you file under AAA. And then there's what you claim, right? And there's a correspondence between those three. The CCPA addressed exactly the same thing for the First to Invent system and came to a rule of law specified here. This rule of law seems to be well suited for the same reasons it was well suited for the First to Invent. Whether this is the way the law will go, of course, is a completely different question. But the big picture is for practice points that disclosure is a bad idea. If you disclose your invention under current USPTO proposed examination guidelines, and you fall into the fact pattern of a third-party disclosure after your disclosure before you file, you're host, to put it bluntly. So disclosure with respect to the U.S. is bad. Of course, disclosure before you file the rest of the world is bad, so why do it? Disclosure generally before filing is a bad idea. Now keep in mind that might change if the law goes to the point where the exceptions are given full faith and credit, such that a third party's disclosure that's only an obvious variation of your initial disclosure is deemed to be an exception, or such that anything that's obvious in view of your initial disclosure that you claim is deemed to be an exception. In that case, at least for the U.S., you'd have full protection of the exceptions provision. Of course, you'd still have the problem that you've lost rights overseas. Now, the AIA preserves, in certain circumstances, the pre-existing law for certain situations. This is the law of prior art, 102G prior art, and the corresponding procedures to kill claims via first to invent interference proceeding or a first to invent interfering patent civil action. That's preserved in the situation where you cross the lines between pre and post on your claims and applications. Hopefully, there'll be not many occasions for this to occur because people keep the lines pre and post of March next year distinct. So applications filed before will contain only claims supported, and applications filed after will not claim priority before and will have only claims supported after. Was there a question? This is the dull, boring part. We'll get into some of the scary parts later. Okay, so for obviousness is pretty much the same as it was. There's no substantive change in the substantive law of obviousness, how you make the determination. What has changed is the date on which you make the determination. So like the prior art section, the date is now the effective filing date of the claimed invention. That would be the date for determining what is prior art and what is obvious under that prior art. And then there's some sections which no longer appear, C, D, and F. F is the biggie. Yes, 102F is gone. There's no corresponding provision under the new statute. By corresponding provision, I mean a knockout for what was considered derivation since 1997. So under current law, under the AIA law, current law coming into effect, there's the distinct possibility of legally issued derivation patents. All right, derivation patent, a term I just coined. It's a patent that claims an obvious variation of something someone knew because they were under a duty, they were an employee, they had an agreement with someone, but they weren't authorized to file for an invention on that application. So you think about it, someone walks off with some knowledge, comes up with a tweak on it, and files for a patent application. The knowledge was confidential, there's no prior filing. So here's the scenario. Yeah, under the derivation timeline, I see that the timeline itself is hard to see, but time runs from left to right, and events occur in sequence as shown down here. First, A conceives, then A discloses his conceived invention A privately to B. Right? B files for invention A prime, his variation, the better widget. Subsequently, A files, but B's patent issues. Right? A's invention is not prior art to B, and so unless there was some other prior art that was relevant, B's patent is valid. Even though B got the concept from A, and perhaps has filed only an obvious variation of A's invention. And by valid, I think that's debatable. There's technical changes perhaps that were made to the law, and the law may be construed differently, but under the straight construction of the statute, that's the conclusion you come to. Well, the consequences are that B may get a patent that can block A from both practicing his invention and patenting his invention. Well, that's bad. You don't want that to happen. If you're an employer and your employees can walk off with your inventions and block you from practicing, that's bad. It's not the way the law should work. It's not the way the law presumably was intended to work. Now, of course, if you're A, you may have some recourse, but the recourse is questionable, tricky, it's expensive. Right? Ex parte, you may be able to show that the invention originated from you, and therefore you can get a patent, perhaps. File a suitable 130 declaration. 130 is the new declaration for showing disclosure originating from the inventor. You have questions, and so that's a question. If you want to knock out B's patent, you're the second filer, you may be able to provoke a derivation proceeding. But again, that's extremely tricky and expensive, as we've heard earlier today. And of course, there's the issue of what happens to the corresponding foreign rights. You know, B gets this invention patented, right? Who wins overseas? Okay, so I've outlined the problem, and now we're going to think about how to address the problem, which goes back into one of those boring periods. Review of ownership and assignment law that's relevant to how a company might address the issue of losing rights when employees walk off, for example, or when there's a dispute between co-owners and one of them goes off on his own and they have a falling out. So the issues that arise and how you handle this depend upon what the law of ownership and transfer of ownership is, specifically the law that I'll present in the next several slides, and then suggest corporate practices that may be able to address those issues, address the possible loss of rights. So that's where we're going. Okay, so I'm going to run through this and make some salient points, otherwise just read through it. Basically, an inventor owns the rights to his inventions. That's the basic law. First owner is the inventor under U.S. law. Right? However, as we know, those rights can be assigned. You can assign your rights under statutory requirement, and assignment of patent rights must be in writing. For the assignment to be effective, the inventor must expressly grant his rights in the invention to someone, typically his employer. However, there's problems because when you hire someone, the inventions haven't been made. And so you may have an IP clause, but if it says merely that you acknowledge that the inventions are going to be owned by the inventor, that doesn't cut it. That may give the employer equitable rights in subsequent inventions during the course of employment, but it doesn't transfer legal title. It's not an assignment. It's a mere promise to assign. And under applicable Federal Circuit law, that's insufficient to convey legal title. Another issue you might have is that your rights may be something you get after the employee starts work. Typical scenario, you send out an offer letter, say you'll employ you at this amount, here's your salary, you'll have health care, et cetera, 2-paragraph letter. And the offeror comes back and says, I accept. Okay, you got a contract, I think. You offered, he accepted, or she accepted. And then what happens if you subsequently ask them to sign away more rights, like IP rights? Well, even if it comes down your way in litigation, you have a problem because that person has a defense, lack of consideration for the subsequent requirement to assign. Now, consider the fact where you make an offer to someone on the West Coast and they accept your letter, they travel to the East Coast, and you get them situated, they've got their apartment contract signed, and then you place before them the employment agreement with its IP terms and what have you. I think a court would not look kindly on that because you've already induced detrimental reliance. They come here, they set up, change the location. So there's some issues with post-start date agreements. There is an implied in fact contract to assign for people that are implied by the facts who have been hired to invent. And so there is a way for equity to work when there's no actual assignment in the employment agreement. The good point is that there's an automatic assignment provision provided to us by the Federal Circuit. They said in case law that if the employment agreement expressly grants now rights to future inventions, I hereby now grant all of my rights during the course of my employment to, John Company. Okay, that's an express automatic assignment. It's express and it's present tense. Another issue is, well, we're talking about contracts, and state laws, U.S. and foreign state laws, generally govern construction of contracts, ownership, and assignment issues. Generally, but again, the Federal Circuit has come back and said that automatic assignment is treated as a matter of federal law. Well, that's good. Now we know which law to look to for an automatic assignment clause, at least in the United States. And although it may seem self-evident, you cannot assign what you do not own. This comes up in cases because people try to assign things they think they own and they don't. The classic situation is sloppy record keeping among a bunch of subsidiaries or kairetsu companies that have interlocking ownership. And I've seen this in my own practice where my clients have spent tens of thousands of dollars trying to secure ownership after the fact, which they thought they already had. Not that I was the one causing the problem. I was the solution, not the problem. Okay, and of course, it's always good to record. One of the benefits of recording is there's now a presumption of validity of a recorded assignment. So it's time for one of those horror moments, foreign law considerations. And the first point is that under the EPC articles, if you have an assignment and you want it to be effective under the EPC, the parties have to sign it, the assignee and the assignor. Assignee and assignor. Now, who signs your assignments? Is it the inventors? Does the company ever sign them? What if you have a sale of company and you want to change the ownership in Europe on those patents, or in any country in Europe, or anywhere else in the world for that matter, and that country happens to require that a contract be signed by both parties? Might be a problem. So that's an issue. Then there's the issues of foreign law and how they're different from U.S. law with respect to assignment, ownership, and the right of priority. And this is the horror moment for some of you. The law overseas, at least in some jurisdictions, is that the priority right is unitary in the owner. If some other entity that's not identical files an application, they don't have the unitary priority right from the prior owners, then they do not get priority. And after they file, they cannot correct. So this law comes from a variety of sources. The cases I point to here, EPO Board of Appeals cases. The first one, T6205, was a situation where there was a Japanese company, Japanese inventors, and I think it was a US related company. And the Japanese companies filed the Japanese applications, the US company filed the PCT application, the EPO application, but it was a different applicant, right? Who owned the rights at the time they filed that application? Turns out it was not the US sub, it was the other people, the Japanese sub. Result, loss of priority, loss of appeal. There's similar cases in the Board of Appeal. There's a UK case, the Edwards v. Cook case, that's particularly relevant and explanatory. That involved a US provisional application, which had 3 inventors. One was a Cook employee, and I believe at least one, and I believe both of the others were not Cook employees. Cook filed a PCT application, filing the normal procedure that we all file in the US. Inventors for purposes of the US, corporation for all other purposes. That's who the applicant is. So Cook was the applicant for purposes of the PCT application for every country in the world outside the US. There were 3 inventors. One of them was a Cook employee. What happened? They got a UK patent. They sued Edwards. These are biomedical device companies. Big business, a lot of money on the line, heart valve cases. And they lost. One of the reasons they lost was it came out in the trial that at least one of the inventors on the provisional application, the Cook provisional, US provisional, was not a Cook employee and had not assigned his rights to Cook when Cook filed the PCT application. Result, irrevocable loss of priority for the UK issue portion of the PCT. It was a UK national stage of the PCT that was at suit. Cook lost. Case went to appeal. Appeals court held against Cook for other reasons. This decision stands. It's still good law in the UK, such as it is, believed to be correct. So if you have filed PCT applications and you haven't checked to make sure that the US priority application was entirely owned by the inventors, you have latent problems in your PCT applications overseas, the national stages, or the EPO regional phase. Okay, so that's the last horror moment. What can you do about these issues? Well, I brought up a bunch of issues. They're all sort of interrelated: the loss of rights overseas, loss of derivation rights in the U.S. And the one thing you can do is think about amending your form contracts, the way you do business. This is in addition to all the other advice about filing often earlier that you've heard earlier with respect to inventions. And this is different. This is to protect the rights of those inventions you haven't filed on yet, for example. So the types of contracts we're thinking about are, besides employment, there's invention disclosures, joint research agreements, foundry contracts, you name it. So you think about these clauses, but start with the employment clause issues. So with respect to employment offers, you don't want to wait until after the employee agrees to work. You want to have all of your requirements up front in an employment contract. However you do that, I mean, maybe there's an employment letter and then there's an understanding in the employment letter that there's subsequent requirements will need to be signed before employment starts, outlining them. The point is, that's an issue. You want to avoid the lack of consideration issue. If you employ someone after, or if you require someone to sign an IP rights agreement after they're an employee, think about the consideration issue. Okay, automatic assignment. This is a good thing. You can use automatic assignment. Almost everyone presumably already is using automatic assignment. All the large corporations with legal departments know about this. Perhaps many of the small companies, solo inventors don't know about this. Include an automatic assignment clause for inventions. Include all the other terms you normally have in assignment, and I'm talking now about an employment agreement. If you include these terms in the employment agreement, if you countersign it for the corporation and the new employee signs it, and it has an automatic assignment clause, well, that complies with requirements for automatic assignment and conveying legal title in the U.S. for patent applications. You can use that in case the inventor skips town, dies, or is unavailable. With respect to the consideration issue, you might want to include some condition as a condition of continued employment term in the employment agreement, or actually give actual consideration for signing a later filed giveaway of rights. So then there's the issue I brought up initially, which is derivation, or a derivation patent. It's not exactly derivation. So how do you avoid the problems here? Remember, if the derivation patent issues from an employee or business partner that walks off on you and files first, then you both have prior art and you have loss of rights. Well, perhaps you can use a derivation clause in your agreements. So before there was no need for this because you own the inventor's rights, you had the first to file information, but now we're, first to invent information, but now we're first to file. So under this concept, if you include a provision which says that any information derived from what someone privately learns from the company is automatically assigned to the company, right? So if it's automatically assigned to the company, it's co-owned, and therefore the filing date wouldn't be prior art, right? You avoided the filing date issue. And if it's co-owned, any rights that accrue would accrue to the company, even if that person, a nasty walking off employee or, disingenuous business partner walks away and does their own thing without you. Okay, I'm making some of this up. This is new, obviously. There's no such derivation clause that's been tested with respect to the AIA. There are derivation clauses in IP rights agreements, but the point is this is new, so you want to think about precautions and safeguards, severability provisions, choice of law provisions. How Federal Circuit law applies to the construction of this clause, for example, for the automatic assignment clause. How you actually define a derivation rights clause is something you might want to think about, something I've tried to think about. There's various ways to do it. I give some exemplary language at the end, but the key points are you want to have a definition that's clear enough that it's enforceable. Right? What is a derivation right? It's based upon this information. It's an obvious difference at the time of termination of employment. for example. Obvious difference from what the inventor invented or knew about privately from the company. Any obvious variations are the property of the company. The other thing you can think about is with respect to publications, specifically patent publications, is how to protect yourself against the disclosure in the former employee's patent application when he's working for your competitor. So he walks off and he gets a better offer, and you see, 2 years later, a publication that's got your disclosure in it. That was your invention. It's disclosed as a sort of a side issue, not claimed perhaps, in somebody else's application, but it's before your filing date. Well, you could prove derivation maybe, or you may be able to capture the ownership of that disclosure to the extent one can capture ownership. Perhaps it does support a claim in the other application with a patent disclosure clause, back up to a patent derivation rights clause. Again, this is an untested concept, but it occurs that this is the kind of thing you should be thinking about in view of the lack of a 102F provision and the lack of first to invent under AIA. Okay, so standard practices, you have invention disclosure forms or a process in a large company for recording disclosures. Well, how about requiring an assignment of the disclosure, an assignment of obvious variation of disclosure when the invention disclosure is submitted by the inventor? Okay, you get an assignment if you countersign it. That's effective for a later filed application, even if he dies or she dies or becomes hostile. Okay. And the next issue is this theme runs through the other types of agreements. I'll probably just skim through some of this. But one thing that may occur to you is whether an NDA is valid under the AIA. It occurred to me, right? I mean, don't take your preconceptions because everything has changed. So if you run through case law, however, it seems that NDAs do apply. They're exceptions. They're not otherwise available to the public. And the underwriting theme from case law under the old 102A was just that. It was accessible to the public. If it was accessible to the public, then it was prior art. If it wasn't accessible to the public, then it was not prior art. So it appears that disclosures under an NDA do not qualify as prior art under 102A. Now, because there's no 102F, again, you have the same problems when you disclose information under confidence, not to, as opposed to being an employee situation, but a interaction between companies situation. And that's something you have to look at carefully with the understanding that, if you have little leverage, little bargaining power, you may not get what you want. But the point is that if you disclose to someone, anyone under confidence, and there's no prior art yet, obviously, and they patent something that's obviously different because they got it from you, well, you have a problem, even if you can even if you can accept their disclosure, the patent disclosure when it publishes. Even if you're not clearly infringing, you've got a problem. So you want to think about the same issues, derivation rights issue and how to protect against it, and NDAs. There's no perfect solution, obviously. And you got to keep in mind also, this is just a final point, that derivation rights clauses are directed to derivation. They're not a substitute for a non-compete clause. This is a recent case from September, First Circuit case dealing with a designer and their foundry in Taiwan or China. So Contour was the design, the U.S., Chance with the foreign, and Chance got the bright idea that they wanted to go into the mice business also. These are, computer mice business. And so first they started knocking off they were found accountable for that. But then they independently designed, knowing what they knew, they independently designed and competed with Contour, right? And the derivation clause in the foundry contract, the clause listed here, agreement of the manufacturer not to duplicate, produce, ... products derived from or based on designers' designs. That was insufficient. That's not a non-compete clause. So you have to keep in context what the word derived means and how you use it. What are we doing on time? Time? Okay, I want to skip to the end then. This is about where I wanted to stop anyway. And the end is slide 96. As I mentioned, there's some issues about derivation. I'm skipping the derivation section. But with respect to best practices, one thing you want to do is to correspond invention disclosures pre-filing with any filing disclosures. PTO is pretty clear that if you put an identification of an inventor's disclosure before filing in the specification, you fess up front, and you put it in the specification. There was a disclosure made on such and such a date. Perhaps it's of a publication you included in an IDS, and identify it as the disclosure, and comply with the other requirements to avoid it. You will not face a rejection because of a prior public disclosure that's not clearly yours. That's a significant feature. At least for academics that tend to publish, that's a good feature. And the other issue, of course, was mentioned earlier, that there's a reason to maintain inventor notebooks or the like, and a reason to maintain them, first to have someone corroborate and have them maintained by someone other than the inventor, someone who will have custody and control, so that under the federal rules of evidence that information can be admissible even if the inventor or corroborator are not around later on, because although corroboration is not a requirement for a declaration to remove a disclosure under 130, it is a requirement for a petition for a derivation proceeding to be granted. There must be some form of corroboration. It doesn't have to be a person. It can be documentary, but there has to be corroboration. And that means maintaining your records. Thank you.
I have a practice question. Under AIA, if anybody filed a provisional application starting on March 16th of this year, and let's say it was a conceptual provisional application, that entitles them to file the utility application on March 16th, being the last day. So anybody that has filed since March 16th of this year a provisional application that could be filed under AIA, which has a much more robust disclosure and ends up having claims that don't get the priority of the provisional application, the question I would ask is, I think a lot of people in private practice might not be monitoring their clients and their inventors. And if their inventor makes a non-disclosure event, let's say in public use event that doesn't trigger a disclosure, it's no longer the case as it was under the prior law that you've lost a year priority. You have now ended up with a dead case on your lap. And the question is what kinds of things, in-house counsel may be more attuned to monitoring these things, but everybody in practice, I would think, ought to be monitoring carefully their clients that have filed provisional starting on March 16th to make sure that there isn't a triggering event, that if they require the priority date of the utility under AIA, that something that isn't a disclosure didn't give them a grace period and killed the case. Any comments or thoughts on that?
There was a comment made, a note made by, I forget his name, one of the primary pushers of AIA published his article in JPTOS a couple months ago.
Armitage, was it?
Yeah, Bob. And he noted that under some situations you could use AIA, for example, when there is a barring private sale under existing law, which you wanted to avoid. You have something that bars you under existing law, secret public use, prior sale, and you wait till AIA kicks in. and then you file. Well, if the PTO is correct that public use and on sale are not bars under AIA, your effective filing date is after AIA. So you've used it to your benefit. I'm not sure that addresses your question, though, but that was the thing that came to mind when you were talking.
That assumes that that's a correct statement.
It assumes that's a correct statement. It may be that the law will go the other way, but assuming that's correct, at least it's an option to try if you have a trade secret you want to patent that's been around a long time.
There is another question. Does anybody else in the room have?
I don't know if I'm right, but with respect to your question, I think you're talking about the bubble situation that's going to occur before March 13th. In other words, right now, I've got some pending provisionals where the one-year date is going to be later than the bubble date. And I'm sure as heck going to try to look, you need to look at those really closely and determine whether to get them filed before or after for the kind of considerations Rick made, I guess, as well as your consideration. And in fact, I have some inventors that are thinking about filing provisionals, which I think I should reconsider whether they should just be filed as non-provisionals to not even have to, get into that situation. So I think that's a great comment.
Partially in response to what he just said, there's really two reasons. The second reason being that we're wide prior art, public use and on sale. And some have speculated that where the U.S. legal system really seems to be fair to a U.S. party and a foreign party, someone can come here from China and avail himself of the legal system fairly in a level playing field. What happens when a large entity has a very valuable patent and someone in China copies the technology and asserts that someone used it publicly in Malaysia? What's the process to go to Malaysia to find the truth and veracity of a declaration that emanates from Malaysia and says, yes, I put this lawnmower, chipper, shredder, catcher on my bagging system, and we did that 5 years ago.
Yeah. There is an issue raised, which is actually the asymmetry in the law now that biases against the U.S. I don't know why the U.S. did this, but we're now under an absolute novelty standard. That's not the standard. We're novelty and obviously standard under AIA. That's not the standard in Europe. So, prior unpublished patent application there can be novelty destroying, period. So we've taken a step further and, shot ourselves in the foot in that respect.
Thanks for the comment. I do have one other question online. I'm not sure if this is best for you or for Janet, but let me just ask it and the two of you can decide. In connection with third-party pre-issuance submissions, if a submission is made against a competitor's application, will the competitor know who filed the third-party pre-issuance submission?
Will the competitor do what?
Will they know who filed? Will they be able to identify who filed that submission?
Yeah, I think the answer is yes, right, Janet? They'll know the person that filed it or not.
The third-party submission has to be signed, so if the competitor wants to keep their identity in secret, they can hire a patent attorney to make the submission, and the attorney would sign the submission so that the client's identity would not be revealed in the submission.
But there is a way that one could veil that easily, yes, and so I think that's an excellent answer. I think it was an excellent question by one
I
of
guess
the
the issue that arises is whether you make statements about a reference and it turns out to be one applied against your own patents. So that's the concern people think about. On the other hand, when you go to a patent attorney, instead of making a submission as house counsel, you've incurred additional expenses and delay. Typically, my experience is typically in this situation, there is house counsel and a focused technology that knows the art better than anybody. And you show them a patent application, they read it, and they say, oh yeah, these two references are the most relevant. Okay, that's the person that should give them to the examiner at the lowest cost. Of course, if he does that with a concise statement that's more than simply a copy of the abstract, he's made statements which may come back to haunt him. I don't think that's a great concern, though. If you characterize the reference by quoting sections of the reference, here's a significant section of the reference. It says this. Look at figure 4. Well, that's what it says. It's not a characterization. It's a concise statement, but it's not a characterization.
Good. Are there any other questions in the room? Thank you, Richard. That's an excellent presentation, and all of his materials are available online. So for the sections that he's rushed through, please feel free to partake of it. At this point, we wanted to open up for any additional questions. If there are any concerns that anyone has about the issues have been raised, because we've raised a lot of issues without necessarily providing a lot of answers. You know, we've been talking amongst ourselves about this grace period, whether we avail it or not, whether a client comes in and whether we want to accept them as a client, whether we want to pick up the piece of work. Can you shirk the risk by telling them something, by signing a letter and fully disclosing to the client? Because we are going to have clients come into our offices on March 16th, and they will have done certain things that we're not going to know the complexities of. We're not going to know with certainty that we're on hallowed ground, and to the extent that we have our clients on a leash and we do have them restrained, we can tell them how to behave now, but we are all going to see clients come in the door that have done something. They've talked to venture capitalists, and they've talked loosely, and they've talked to their patent lawyers, and they've talked to their friends, and they're going to ask you, what rights do I have? And you're going to have to personally make a decision as to whether you accept representation on their behalf, and what you can do to mitigate what they might have done, and yet it's difficult to predict what the courts are going to tell us.
I think one of the implied concerns you're addressing is, in actual practice, if someone comes in and says, I want to file an application, and you know it's invalid, then are you obliged to file it, and they're your client? Do you want them as a client? Well, one of the ways we have handled situations like that in the past, perhaps you've done the same thing, is you have information known to your inventor, or known to the company, that's not otherwise available, public use information. You have a Rule 56 duty. They have to file paper identifying the relevant facts to the patent office. Sure, you can take them on as a client for an invalid application, but maybe that's not invalid in Russia or somewhere else. Maybe there's some additional disclosure you squeak out of it before you file it, and so you can't rush to judgment in situations like that. Yeah, there's bad facts in a lot of different cases. This is just another kind of bad fact. I disclosed it not under confidence to 5 different corporations, and they all kicked me out. Okay, well, exactly what did you disclose? Was it the entire invention? What about your improvements since you've gone on? It's always the facts that matter.
Yeah, in some of those cases, we won't know. I mean,
you won't know until you draft the application and
Yes.
actually work with them. So you tell them what the law is as you know it, what the risks are, and that given those risks, here's at least what you have to do, and if you move forward, this is what you might be looking for. What are the changes? What are the differences? You're going to have to disclose all of this to the patent office to comply with my duty to disclose and your duty to disclose, and then see what happens. But you may have foreign rights at risk or at issue also. The laws may be different. Was your disclosure enabling? Lots of different issues. So I think you can't simply walk away because they tell you that they shot themselves in the head. They maybe only shot themselves in the shoulder.
But it's also the case that you can't pretend that everything's okay.
You can't pretend everything's okay.
Any additional questions, topics?
I have a question for Janet if there's no other questions. It's a question I asked privately
Janet.
of Robert earlier regarding derivation. What is the standard for a derivation petition to show derivation? Is it anticipation and insubstantial differences, or obviousness based upon the disclosure provided to the deriver? I know what the rules and the law and the rules and the comments say, and they didn't answer my question. That's why I'm asking.
Well, I'm afraid I'm going to have to defer on the question as well because I don't know the specifics. I mean, for a derivation petition, the petitioner is going to have to show that there was some form of well, first of all, that the invention's claiming, the alleged deriver is claiming the same invention as the claimed inventor. And then there has to be a showing of some form of a communication between the alleged inventor and the alleged deriver such that there was a transfer of information. I'm not sure if, I'm suspecting that's probably not answering your question, but I don't know if I can be more specific on it.
Okay, let me just lay out the question. I skipped the derivation section. Derivation requires communication of information to another party. It must be enabling, all right, it must be clear. It's
Correct.
explicit. That's the classical description of derivation, but the law changed in 1996 or 7, the applicable law, because at that point derivation was expanded by case law to include obviousness as obvious differences from what was disclosed to the deriver. And the PTO has, sorry, the PTO, I was going to say danced around, but meaning no disrespect, the
None
PTO's
taken.
promulgation and the rules don't clearly take a position one way or the other. You know, first they said, well, in response to comments, people asked what the standard was for same or substantially the same. So we've made it a definition in the new rules. It's same or substantially the same means patently indistinct. Okay? What does that mean?
What
And
does
we
that
know generally what that means, but in the context here, we don't. The rule says that's the requirement for a showing of the claim correspondence, patentably indistinct claims. But there's a different section, different comment, different section of the rule, the petition section, which defines derivation, right? And it uses language. So it's unclear to me exactly what scope of correspondence there must be from the disclosed information to the deriver's claim. That's what's unclear. Perhaps because there's no case law, odds-on is no longer the basis for which odds-on was assigned, which was the existence of exclusions under F and G, no longer exists. And so the underpinning rationale for odds-on no longer makes any sense. The traditional law was that derivation is exactly what you disclose, not obvious differences. So hence my confusion and the reason for the question.
So I'm not going to be able, unfortunately, to clarify it anymore, because I think we're going to have to watch the board and see how they handle derivations and treat the patentably indistinct standard for guidance. I can't answer more than that. I'm safe to know my predecessor, Mr. Stern, wasn't able to answer it either. So I'm sorry, I can't give more specific information. Whew, I'm safe.
I tried.
Sorry.
Richard, there is one other question online. And I guess since you're up, you can probably answer it or attempt to. If not, someone else here can answer it. And the question is, under AIA, what changes to design patent protection?
Oh boy, that's a good question. And the reason it's a good question is because there is some ambiguity in the statute and the rulemaking and the applicability provision of the rulemaking for the inventor's oath and declaration issues. Now, OPLA has told me, I forget who's the head over there at OPLA, but he told me and some of his other people I talked about the issue that there is a confusion because the AIA doesn't expressly address design patents per se. The applicability provision that deals with the oath and declaration, which impacts design and plant patents, says an application filed pursuant to, under 111A. Now, or 363, but 363 is implied. The trouble is design and plant patents, and to extent reissues, because the question is whether you file an application that's a design patent, which is 171, I think, and plant is 161, under 111, or whether you file them under the authorizing statute, 161 or 171, is an open question. I mean, I went through this and spent days on it and came to the conclusion that there was no conclusion, and you couldn't tell from the statute and the rules. But it's a regulatory issue. The PTO has issued a form, which is the inventor declaration form, and they say that's applicable to design patents. So in that sense, PTO has decided the issue for us, even though they didn't identify it as such in the rulemaking package. That's the best answer I can give, is that if the PTO accepts your declaration and you file a design patent, then under standard federal circuit's construction of the statute, once that patent issues, you can't challenge the PTO's determination on that regulatory issue. It's not a condition for invalidity.
Anyone else want to add to that?
So that is correct. The PTO is treating a design application as being filed under 111A. So the inventor's oath declaration provisions apply. So if a design application is filed after September 16th, the declaration in the design application must meet the AIA requirements, and the Patent Office has created a form on the website for use with a design application with an inventor's oath or declaration.
Just as an aside, if you want to read the reasons why it's unclear, there's a paper on my firm's website on that issue. I mean, we know what the answer is, but if you go through and do the analysis, you can see the analysis. You come to the conclusion that there's no conclusion from the law and the regulation promulgation. So thank you for clarifying.
With hindsight analysis, that was an excellent answer, Richard. I think there's a question back here.
Yes, Richard, when you ran out of time, you were just going into NDAs and changes and how ones didn't work anymore.
Oh, yeah, the big change is that there's two changes. One is with respect to NDAs and JRAs, there's no derivation. You disclose something, someone else theoretically can get a derivation patent, like I'd mentioned earlier. In fact, if you go, the small company, big company, disclose your invention to the big company, sign a JRA, an NDA, they may decide to file, 7 similar applications of their own unrelated concepts after they see yours and then walk away because why bother? They've got the market locked up. So there's an asymmetry in bargaining rights there, and that's an issue. That's one issue. The other one is that with respect to the JRAs, as we've heard earlier, you can think about a JRA, do a disclosure, say, we're in the same art. We're 2 companies. We have a whole bunch of applications just filed, each of us, related technologies. And if we don't team up, then all of our pending applications are going to knock out all of our subsequent inventions. At least it's likely, because you're in a closely related art. But if you sign a JRA and decide to work together, guess what? All of the applications you file after the date the JRA is signed, even on insubstantially different matters, the other party's patent filings won't be prior art to you, so long as they haven't published. They're not disclosures yet. They're priority date based prior art, and so they disappear as prior art. That's the benefit you get now under a JRA. Under the AIA, that's the benefit you will get for a JRA, Joint Research Agreement. Under current law, it's date of invention that counts. So if you made your invention, you were have the conception, and then you sign the JRA, that conception, if later filed as an application, does not obtain the benefits of the exclusion from prior art of the other party's pending applications.
Okay.
You look confused, I'm sorry.
Well, I was just, the NDA's kind of been, a classic, well worked out legal document that is pretty readily available at no charge. It's one thing that an independent inventor could generally rely on getting that was reliable to go out to machine shops or whatever. Is that completely out now? Or has this document changed substantially with this legislation that you really needed to see an attorney just to get something as simple as an NDA?
Well, there's NDA forms all over the internet. I'm sure you can pick out the one that suits your pleasing.
Right.
I don't think you need to go, can't give you legal advice on an issue of law, but there are NDA forms available. And it
I
seems
know
like
they
the idea
have
of an
been,
NDA
but I'm
is
just
not changed.
concerned that the new legislation has made them obsolete, and is that not the case, that they're still
Well,
basically
you take
okay?
the idea where you go to your machine shop, you have this invention, you send them specs, and they've signed an NDA, and then they have a bright idea of making something a little bit different from what you sent to them, and they get a patent on that. That's the kind of thing you want to watch out for. Your contractors, your foundries, may decide to go into competition with you because now they can.
So those activities, this is a very good point, because the NDA is still a very important tool. The trade secret relationship is still a very important tool, but the fact that they can now go out and do what Richard has said creates a complexity that this is another area that one will want, joint research agreement. That's a significant protection because of the change in the law. You probably want to add that to your toolbox.
You'd want to have the derivation provision to prevent them from doing what I just said. So that's the idea of having a derivation rights clause. That, hey, you're under an NDA, we're going to disclose inventions, you're going to do work for us, but you can't derive inventions and then compete with us. You can't patent inventions you derive from what we disclose to you. It's not fair. That's the idea of the derivation provision. Protect your rights.
Carlos, you have a question?
This is related to what you said. I may have been doing this wrong, but I've included duty to assign. I mean, I've always recommended that in joint venture agreements or agreements, like you said, to make sure that there's always some clause that talks about the IP and what happens to the IP. Because that's the classic scenario, you know, where you go to a machine shop and all of a sudden now they're filing patents on what you know, based on what you told them, which I think is the duty to assign clauses. I mean, I've been using duty to assign, and maybe I'm using that broadly, but is that enough to protect you to say that you're going to work for me, but by the way, as part of doing this work, you do hereby assign, and I think the standard language covers that.
Yeah, I mean, some advice people give on JRAs is to make sure you have an agreement as to the IP rights as part of the JRA. I think that's what you're talking about.
Yeah, but you're saying adding a derivation specific clause in addition to that.
Well, you know, JRAs and NDAs are a bit different. If you're talking about machine shop work or foundry work, you don't want your foundry to compete with you, whatever it takes to get there. And trying to lock up the rights you otherwise had under existing law for them not deriving inventions from you is what you can do perhaps with a derivation rights clause in an NDA. And it's different from a JRA.
I think both of those, what Richard's pointing to is in a more developed collaboration, but I think what Carlos is pointing to, and I deal with this a lot with an individual inventor or startup company that goes to a machinist, an orthopedic surgeon goes to a machinist and says, oh, he's never going to contribute to my invention. But, you know, the orthopedic surgeon goes, well, why didn't you make that out of nitinol? And, you know, the orthopedic surgeon's going, you know, now he's a co-inventor. So this is the clause that Carlos uses and I often use in every opportunity, especially with somebody that's collaborating with someone who's an unlikely co-inventor who has no obligation to assign, to try to wrap that up. But there are going to be a family of these issues now in collaboration agreements where it gets even more complicated because of the law that you're going to need to try to protect.
And if you do need to name the machinist as an inventor, it sure be nice to have an automatic assignments clause in the contract with them so you can file that as the assignment in order to get the application rolling. He may be reluctant to be an inventor named on the application.
Any other questions? Thank you very much, Richard. Thank you all.